good afternoon, everybody. Kind of a chilly old day in O-Town. This is Law 2020, brought to you by your friends at the BCN Law Firm. That, of course, is Boyette, Cummins, and Nalos. And you can always reach the law firm at 352-394-2103 or 855-LAW-2020. We'll have Tim sing that to you after a while. That's 855-LAW-2020. Offices Winter Park, Claremont, Lakeland, and a brand new facility in the Villages. That's right, and that's where I call home. And a new neighbor of mine is Melissa Williams. She is an elder law specialist with the BCN Law Firm. And how are you, Melissa?
I'm doing great. I'm so happy to be here today.
How long have you been practicing law?
I've been practicing for 3 years now.
All right. And you know, one of the things I've noticed as I get into my early 60s is we seem to go through our entire lives just thinking that, oh, I can't wait to retire. I get to fish every day and golf every day and live in a wonderful country club community. But we don't think about elder planning and the laws that affect us past then, and there's no education of that. You really need to sit down with an attorney and make sure everything is planned out, right?
That's very true. It is very important just to get that education out there, and BCN Law Firm, as well as myself, are trying to educate all of the elders out in the Villages community so that they know what they need to have in place in order for their family members to receive assets after they pass away, but also make sure that they have all of the documents in place to make sure they're taken care of if they do become incapacitated during their lifetime.
All right, very good. We're taking your calls on elder law or any legal question at 855-297-9696, 855, that's toll free, 297-9696. You could text us at 21232. A lot of people still don't understand how to do that. If you've got kids in your house, they'll teach you how to text. But simply on your smartphone, you see the messaging feature. That's the envelope on your phone, that little logo on there, that icon. So all you do is where it says recipient, just put the numbers 21232. 21232. And then in the body, you just ask your question to Melissa Williams, Elder Law in the BCN Law Firm. What are the 4 documents you would recommend that everybody have in place way before they get into their 60s?
Everyone definitely needs to at least have a simple last will and testament. That will allow you to name the person that gets to distribute your assets and also name where those assets will go. And then you need to have a power of attorney. And the power of attorney allows you to name an agent that can help you with your banking and your real estate if you ever become incapacitated and you're unable to handle that yourself. The third document would be a healthcare surrogate. And the healthcare surrogate lets you name up to 2 or 3 people that will help you do any medical decisions if you can't handle those medical decisions. Maybe you're incapacitated or you're in surgery. And the last document would be the living will, which is different from the last will and testament. The living will allows you to choose whether you want to be taken off of life support in certain situations.
Okay, and you know, a lot of times you're dealing in the state of Florida, especially with blended families. You have a man and a woman who maybe have lost their spouses or divorced their spouses earlier in life, and then they decide to get married in their 50s or 60s and live out their years in the retirement areas of Florida. And that gets extra complicated, doesn't it? Because you got yours, mine, and sometimes ours. Absolutely.
And we see that a lot in the Villages area. You know, people will move there with their first spouse, and then the first spouse may pass away. A lot of times those clients will come in and actually have us do prenuptial agreements or postnuptial agreements as well. Not saying that they don't love this new spouse. They just want to make sure that they're able to give their assets to their children from the first marriage. And same thing for the new spouse. They want to be able to pass on assets. So that's important. And also important with that is to make sure that you look at all of your bank accounts. Make sure your assets are not payable on death to an ex-spouse or to someone who's already passed away. That could get you in a situation where you end up needing a probate, and you could have already taken care of that if you would have paid attention to who you had named on those assets as beneficiaries.
Okay, and just for points of clarification, you're not exclusive to the villages, right? You'll handle the people at all the other retirement communities up there, and they're surrounding all that area.
Absolutely. You know, we are willing to go out to clients' homes if they have issues with coming to our office if it's too far away. I am located out in the villages, but I go up to Claremont as well if I have clients that are in the Claremont area. You know, I have clients out in Leesburg as well, so we're more than happy to surround or to support any of the surrounding areas.
Yeah, and let's not forget all the folks up in Spruce Creek and all those other places,
right,
and Continental and all that. There's a lot of retiring going on in Central Florida, no doubt about that. Richard, thank you for calling. What's going on?
Well, I'm a senior, 80 years, and my girlfriend, we live together, we're single, and we live in my home, and it's underwater. And I was thinking that if I rented the house to her, even though we continued living there for 2 years, I would then be eligible, if we sold the house at a loss, if I could write it off as an investment property.
Have you talked to a tax accountant on that, Richard?
No, we have not. As we thought maybe that a legal beagle like yourself would really know all the answer quickly.
Melissa, do you know? Or hey, could you hear the caller?
I actually could not hear the caller, so I'm not sure what the question was.
Let me give you the scenario. The scenario is as follows: the gentleman lives in a home, and his live-in is a girlfriend. They're not married. The house is upside down. They want to keep the home for 2 years. He wants to know if he rents it to her, if it then becomes an investment property when he eventually sells it so he can get a write-off. I would think one of the first things that comes into it that I would question is, isn't the IRS going to ask him if he was also a resident of that house?
Right, that is correct. Unfortunately, this is not within my practice area. I focus more on the estate planning and the elder law section, but we do have attorneys at BCN that would be able to handle this. Specifically, Ken Costello with our Claremont office would be more than willing to give you a free consultation to go through this matter a little further and answer those questions for you.
Okay, Richard, if you wouldn't mind taking down a phone number, Ken Costello is the one who can help you out. A few minutes of free consultation is yours. First thing in the morning, just dial 855-LAW-2020, and for simplicity's sake, it's 855-529-2020 or 352-394-2103, 352-394-2103. I would guess that the IRS is going to ask if that wasn't your permanent residence as well. But again, I'm not a tax attorney, but I have done an awful lot with the IRS around here. Okay. This comes from a texter. Dear Melissa, why is the family unable to sue a physician for the death of an elderly person for medical malpractice if they do not have minor children in Florida?
Well, that's an interesting question as well. I, again, do not do medical malpractice, but other attorneys in our office do practice that form of law. So I'm not completely sure about whether that is true, that you're unable to sue a physician for death of an elderly person for medical malpractice. As far as nursing home care and nursing home abuse, that is something that is very complicated. If you'd like to give us more information, we'd be happy to help you with that. Again, give me a call. It's more of a complicated topic than I can really answer over a quick phone call.
All right, very good. A lot more details need to be. 352-394-2103 or 855-LAW-2020 is how you get a hold of Melissa during the week. Offices Winter Park, Claremont, Lakeland, and yes, now even in the Villages on Highway 466. We will take a break for the three big things you need to know. Then we're coming back with more. If you have especially elder law questions, things that you need to be thinking about, the will, the living will, the surrogate, why you do not want to go to the big box store or online to have these documents done. We'll talk about that and much, much more. You can call us at 855-297-9696. We will be back. We're asking the experts. We're 7 minutes away from news, traffic, and weather, and we'll be asking the experts all afternoon. It's a great lineup. If you need health advice, you need anything medically, you want to know about fixing up your house. Right now we're talking about, of course, elder law with the BCN law firm. Melissa Williams is with me. Elder law is a very complicated jungle of forms and checkups that need to be done often because your life changes or circumstances change. And that's what we're addressing right now at 855-297-9696, 855-297-9696. Open up your smartphone, go to the texting feature, and put in 21232 in the recipient level. And then in the body, you've got about 160 characters. You can write more than one. Text if you want, and Tim will put them all together for Melissa Williams. So, Melissa, we were talking about the three documents that people really need, and there are more. But how often should people then meet with you and just say, hey, let's just review my documents and see where I am right now?
Well, we suggest that our clients come in every 3 to 5 years. If they haven't come in between that time, there is quite a possibility the laws have changed at least slightly, and we may need to get things updated for them.
Now, there's a lot of things, too, that people did not have in other states that they'll have down here, and that's where BCN Law Firm, knowing the turf, knowing what goes on in Florida, can help. And one of those is the homestead legislation. So, again, that's going to affect all of their real estate assets, right? Very
true. We suggest that if anyone comes in with documents from out of state, especially coming into the Villages, most of those residents have not lived in Florida before. They just became Florida residents. Just come in, get your free consultation. We'll look through all the documents that you've had prepared out of state and make sure that they comply with Florida law.
Okay, and why would you recommend that somebody not run out to the big box store or go online and say, give me a will form and I'll fill it out right here because it'll be easier? Why not?
Well, we definitely do not suggest that. There's actually statistics out there saying that 80% of those documents that are filled out by a layperson will be done incorrectly. The bad thing about that is you usually don't find out you made your will out incorrectly until after you've passed away. And that means that your family members, usually your spouse, will have to deal with that incorrect will. They may end up having to go through a full formal probate just because you didn't know what you were doing. They may have to have judicial involvement as far as who gets the assets. It may not be the way that you wanted it to be. So it's very important to visit an attorney who knows what they're doing, who's licensed in the state that you are a resident of, so that they can review those documents, make sure that the documents are right for your specific situation. And it's especially important if you are elderly, to make sure that you're going to an elder law attorney who can look at it not only from an estate planning point of view, but also to look at it and make sure that you are covered if you do become incapacitated in the future. We want to make sure that we can try to avoid having to do a guardianship. We want to make sure that your assets are in place so that if you need to go into a nursing home, we can get you qualified for Medicaid benefits or possibly VA benefits if you need those.
All right, very good. And now at this time of year, an awful lot of the transplants to Florida, if you'll forgive the term, are bringing in their family members for the holidays. Is that a very good time to sit down around the table or maybe visit your office and say, here's what we have in place so the kids will understand this?
Absolutely. We're more than happy to have families come in if they feel comfortable bringing in their children or grandchildren to discuss assets and different legal documents. It makes it a lot easier once that person has passed away. I suggest when my clients come in that they give me just a basic list of the documents that they do have, the assets that they have, and whether or not those assets have beneficiaries listed, so that once they pass away, I have a list that at least I can help that person that they've named as personal representative. I can give them that list and say, okay, this is where we need to start, and this is how we need to distribute the assets according to what your parents have discussed with me.
Explain to people, it's still a mystery in Florida, and I think nationwide. I think it's a mystery of what probate is. How does this all work?
So the probate process comes into play if there is an asset that was in the deceased person's name alone. So say you have a husband and wife, the husband owned a bank account and it was just in his name. Once the husband passes away, the wife doesn't automatically get it just because she's the spouse. We'd have to go through the probate process, which is the court process, which says where that asset would be distributed. And that goes in accordance with what your will says. So if husband's will says everything goes to wife, then the judge will look at that. He'll approve the personal representative to go ahead and make those distributions to the wife. But the probate process is a 6 to 9 month process. It can be longer if it's contested. And we would rather our clients be able to set up a trust if that's appropriate for them so that they can avoid that process. And that allows them to not only avoid having the court in the distribution process, but also it's less costly when distribution needs to come into play. And it also avoids the will being part of public record.
So is that advice you would even give to the person if they were very, very smart people, even to down to not only titling and the deed for the home, but also when they buy a new car, how it's going to be titled, whose name's going to be on there, and bank accounts and retirement accounts?
Right. We can give all of that advice. We'll sit down. We'll go through everything with our clients so that they can make sure everything is titled correctly.
All right. If you have questions, and even you don't have to be retirement age to ask questions about this, because one, you will be facing this sooner or later. But number two, a lot of you will find that as your parents get older, you have to kind of take over some of the role here and advise them of the things they need to be doing, because maybe they don't hear this program and you do. So if you have questions, you can call in. You don't have to use your real name. And if you text, we will not give anything about your phone number. But go ahead and make contact with us in the next half hour, 855-297-9696, 855-297-9696. You can text us at 21232. Dave Wall and our fully staffed newsroom standing by with news, traffic, and weather on News 96.5. And if you missed it on the traffic, the Turnpike southbound exit 249 Osceola Parkway is at a standstill right now, so you're going to need to find alternate routes. So be looking at your GPS and find a different way to go. Just hit alternate routes. All right, this is Law 2020, the BCN law firm that is Boyette, Cummins, and Nalos. You can reach them anytime at 352-394-2103, that's it, 2103, or 855-LAW-2020. That's 855-529-2020. And we're talking to Melissa Williams today. If you have a question for her, you don't have to use your real name, 855-297-9696. Or text us at 21232. Melissa, what are some of the real problems you have seen since you took over this part of law for BCN Law Firm?
I think one of the real problems in elder law is that clients don't realize that they could possibly be eligible for Medicaid. They hear that the Medicaid assets and income limits are $2,000, and they just assume, well, there's no way I'll ever get down to $2,000 in assets or $2,000 in income. and they just assume that they have to private pay for their nursing home care. So it's very important that we get out there and let clients know that there are ways that you can structure your assets so that you can get on Medicaid benefits, and you are not paying up to $14,000 a month for private pay Medicaid or nursing home care.
All right, very good. And during the break, you and I were talking about some of the nuances that come up, especially in the state of Florida, because of our Homestead Act and others, that the family may not be informed as to what Dad wants to do with the house. But he did tell all the kids that, that house in the country club community or that house in Zellwood or Leesburg is going to the kids upon his demise. And then there's a little fly in the ointment, and that is what?
That would be the fact that there is still a spouse that's living. In Florida, the spouse has a right to that homestead property. And so even if the dad tells the kids that they get to have it, the law says that the spouse actually has a right to that homestead property for her lifetime. There is a new portion of the law where the spouse can choose to take a portion of money instead of keeping the property for their lifetime if they don't want to actually live there, though. So there are ways around it. The best thing to do, though, is make sure that you are actually working with an attorney who knows estate planning as well as elder law, so that they can make sure that everything is properly in place and that dad isn't just thinking that it's that easy to leave everything to the kids.
And we're talking about spending a relatively low amount. I mean, you could compare it to the amount of Starbucks over a month, compared to maybe having a $10, $20, $40, $100,000 mistake at the end of your life if you don't get good counsel, right?
That's absolutely true. And again, we do free consultations. So if we see that everything looks fine, we'll let the client know that, and maybe they need to come back in 3 to 5 years to make sure that everything is okay. At that point, the law hasn't changed. So many times, it's a small fee to make sure that everything's okay, but a free consultation, and you may get out the door without having to pay any type of fees.
Do you ever get invited to speak to clubs, groups, or organizations and talk about this kind of thing?
I absolutely do. I do estate planning and Medicaid seminars out in the villages. I speak with clubs. I speak with assisted living facilities, and we also do our own seminars out at the library as well.
All right. And again, if you would like to set something like that up, you could talk to Melissa or one of the office staff at 352-394-2103 or 855-LAW-2020, 855-529-2020. And again, a number of attorneys, everything from criminal law to estate and business planning to litigation to accidents, you name it. The BCN law firm is armed and ready to help you, and they're not afraid to go to court. So, that's the kind of thing you need to think about. Melissa Williams talking elder law right now. Let's get back to some of those crazy stories that you've seen come along, because we only do these so you folks won't have to suffer these problems.
That's very true. One of the craziest stories I think I've seen is fighting over someone's ashes. And that is as simple as writing down what your wishes are once you pass away. If it's written down, then the court and your family has to abide by your written wishes. If there are not any written wishes, then we see a lot of fights, especially in the villages area where you have second marriages or third marriages. We'll see that the children, even though they may be distant from their parent who has passed away, they may end up getting in a very large fight with the new spouse over who gets these ashes. We've also seen fights between siblings over who gets the ashes because one was upset that she'd have to drive too far to visit dad's ashes. But if dad would have listed out his wishes and said where he wanted to be buried, if he wanted to be cremated, where he wanted his ashes to be placed, and who should hold those ashes, it would have saved the family a lot of strife and, honestly, a lot of money. They spent a lot of money on attorney's fees just fighting over who would get, the ashes of their father. And unfortunately, these days, the court has decided that ashes are not considered property, so they really have no place of saying who gets them. We'd have to appoint someone to make that decision instead of allowing the family to make the decision. So really fighting over these things are kind of taking it out of the family's hands and putting it in a stranger's hands to make that final decision.
That is just crazy. Now, we all are familiar with the Casey Kasem situation where his body wasn't even buried for months. Is that isolated, or does that ever happen?
Absolutely not. We've seen that as well, specifically in a situation where a client decided they wanted to leave all of their assets as payable on death or transferable on death to some of their family members. That meaning they didn't have any assets that were available to necessarily bury themselves once they passed away. And unfortunately, they had several bank accounts that had tens of thousands of dollars, but the people who received those bank accounts didn't necessarily want to spend any of their money, as they saw it, to bury this person. So they had to be placed on ice for several months until the court could get involved and figure out a way to get someone to contribute money to have them buried.
That is absolutely crazy, but it does happen, doesn't it?
Absolutely. I mean, we see things that you would never even imagine. So if these people would just take, 30 minutes to come and do a free consultation, we could plan everything out and make sure that these things didn't happen to them or their family in the future.
I almost see a scenario where somebody finally listens to this program enough where they say, yeah, okay, we're going to do it this week. I mean, we're approaching the end of a year, so it's time to not only shop, but it's time to clean up all of your problems, and this would be a good way. But I can almost see a scenario, and tell me if I'm right or wrong, where somebody finally comes into your office and say, we've been putting this off for years. We're in our 50s or 60s, 70s, 80s, and we really should address this. And then when they're done, they say, well, that was simple. I didn't know it was going to be that easy. And they kind of wipe their forehead and go, phew, glad that's over. And then that's one less thing.
Absolutely. We see it all the time. I've met many people out in the villages that say, I know I need to do this. I've been putting it off for 5 years or 10 years. I just don't want to talk about it. And I understand completely. It's not something that anyone really wants to talk about, the fact that they're going to one day pass away. But if you don't talk about it and you don't plan for it, it's still going to happen. So it's important that you sit down with your family members, discuss it, sit down with your attorney, and make sure that it's going to happen the way that you want it to happen. Make sure those assets are distributed properly. Make sure the people that you trust are going to be the people that are in charge of distributing your assets. It's so important, and unfortunately, we see all the time that they put it off just because of fear. And what I try to do is I just try to quell those fears when they come into the office. We try to make it a lighthearted meeting. I don't want to talk deeply about their impending death because, we're all going to pass away, but they need to have a little bit of fun with it. They need to realize that it's not something that's doom and gloom. You're not going to pass away once you sign your will.
Now, can they also address in any document of some sort how they want the memorial to go and the funeral to go? Can they actually almost spell it out?
Absolutely. We have a document that we can have them sign, just their funeral arrangements, what exactly they want. We'll include that with their will or their trust, whatever they decide to do. And we also have funeral homes in the area that do pre-need planning as well. So we can work with them and the client to make sure everything is in place.
I'm thinking, too, of not only couples in the retirement communities around all of Florida, not just the villages, but all over Central Florida. And I'm thinking about, the fact that a lot of people are a surviving spouse and they're all alone in the house and probably haven't made any arrangements of any type of where the papers would be, who would have access to the papers, who would even know where they are.
Right, and we see that a lot as well. It's important for them, and especially them, because they're by themselves. Their children may not be able to visit all the time. They need to go in and see their elder law attorney or their estate planning attorney and make sure that everything's in place. Make sure that there's someone in the area that knows which assets they have, what their wishes are, so that person, that attorney can share those wishes with their children once they have passed on.
All right, very good. We're going to take a break. We've got 3 big things you need to know, but if you have questions for Melissa, 855-297-9696, 855-297-9696. Text us at 21232, 21232. Our special guest is elder law attorney Melissa Williams of the BCN Law Firm. We'll be back. Hey, we're back. Yes, indeed. The BCN Law Firm. That's Boyette, Cummins, and Nalos. They visit us with Law 2020 every Sunday at noon, taking your calls at 855-297-9696, 855-297-9696. Text us at 21232. 21232. And during the week, you can talk to Melissa Williams. She is our elder law attorney, and she can be reached at 352-394-2103 or 855, that's toll free, 855-LAW-2020, 855-529-2020. She represents the Village's office. There are also offices in Winter Park, Claremont, Lakeland, and the Villages, many associates, all of them specializing in various types of law. So one call literally does it all. Okay, worst case scenario. Person lives alone, any one of our country club communities, maybe just out in the countryside, don't have any documentation at all, and they die.
Well, the worst case scenario would be that they would have to go through probate. If they had assets. So let's assume they do have assets. This means that the court looks at who they're related to. Do they have a spouse? Do they have any children, grandchildren, brothers, sisters? And from there, the court will decide, based on our Florida statutes, who will receive any assets that this person has. The court will also be in charge of appointing a personal representative for that estate. And the personal representative is the person that will have to distribute the assets to the deceased person's relatives. So really, if you don't make a plan at all, what you're doing is you're giving all the power to the court, allowing the court to decide who gets to distribute and who actually gets all of your assets. And in most cases, if you don't plan, then you're going to end up giving assets to people that you didn't want the assets to go to.
You know, and the other thing I can think of is this probably doesn't happen within 24 hours, does it?
No, absolutely not. Like I said, it usually takes 6 to 9 months. In certain situations, if it becomes contested, maybe you have children that think they deserve everything or a spouse that thinks she deserves everything, it could take up to 2 or 3 years.
So, in other words, nobody's making a house payment, a car payment. Nobody's keeping up the house. That house may disappear from the family totally because they'll do a foreclosure.
Right, and we do try to avoid that by getting the personal representative appointed. Hopefully the court would pick a personal representative that was actually responsible enough to do the job and make sure that those assets are taken care of and not wasted. But that becomes difficult sometimes because there are no assets to pay for the mortgage or to pay for the upkeep of the house. And that personal representative sometimes has to dig deep into their own pockets and pay the mortgage for a while and hope that they'll get reimbursed in the end.
Wow. Now, how about the person who has put this off and is now showing the first signs of dementia or Alzheimer's? Are we in trouble?
We are in big trouble at that point. That's why it is absolutely important to get your documents done while you're competent. If you are at the point where you don't understand what documents you're signing, we can't allow you to go ahead and execute those documents. The only way you can do a will or a power of attorney or healthcare documents is if you understand what you are doing. So in some cases, we actually have to ask for doctor's notes to make sure that that person is competent to sign documents. If we determine that they're not, then we end up going to a different stage where we have to do a full guardianship and get the court involved and have someone appointed to take care of that person, make sure that their healthcare decisions are taken care of, make sure that they're taken care of financially. And that's a really burdensome process, the guardianship process, because the court is involved in everyday spending, from down to how much is spent on that person's food to how much you spend on their clothing or recreational activities.
Wow. Again, this may have turned on a light in your mind, and you're thinking this week you may want to contact Melissa Williams. And let me give you the contact information again, 352-394-2103 or 855-LAW-2020, 855-529-2020, the BCN Law Firm. They do have offices convenient to Orlando. They're in Winter Park, over on the west side, Claremont, down south, Lakeland, and now north and west, the villages. So they've got the area pretty doggone covered, and everything looks good. Now, this all brings to mind the Shivo case from some years ago, and people who are new to Florida, they heard about this because it was on the international news for about a year, and that was if you don't have these documents in place, it could be that you don't need them when you're 60 or 70. In the Shivo case, that person was only in their early 30s.
Absolutely, and I couldn't agree more. We had a client call in about his son who was in his 20s, actually, who had gotten in a really bad car accident on the turnpike and called us saying, he received a check and I don't know what to do with it. Well, unfortunately, his son didn't have a power of attorney yet. So we had to go through the full guardianship process because his son was incapacitated and we couldn't get that check cashed so that the parents could pay for his medical bills. It's important just to get it done, especially if you're young, to get those documents, the power of attorney and healthcare documents done at least.
Melissa, where do you recommend that the couple in Florida who has all northern relatives, where should they keep their papers? How can these be distributed to the family or the executor, because we never expect death. It just happens.
That's very true. We offer to keep the original wills at our office if our clients choose to leave them there. That way, their family members can just contact us and we can make sure that that will is given to the court. We also suggest that they give copies of the power of attorney or leave copies of the power of attorney in a safe. Or if they have access to a safe deposit box, they can name one of their relatives to be on that box with them so they have access to those documents as well.
Well, how many times have you come across, and I know it's got to be a huge number, have you come across where the kids don't even know who the attorneys are for the family?
It happens all the time. Unfortunately, most attorneys they put their card on the document and then the card never makes it to the children. We try to put our names on all of our documents, leave it in a folder that has our name on it so that the clients know. But unfortunately, it happens all the time.
Wow. Okay, we're down to less than a minute. You would recommend, if somebody is just moving to Florida, and it happens hundreds of families a day move here, that they take their documents that they may have already prepared and run them by your office. You give a free consultation, right?
Absolutely. I'd love to look over their documents for them and just make sure everything's in line.
All right, very good, because things change when you get down here. You've got different residency. You've got a lot of things that Florida law is different than other places. So get those documents checked over. BCN Law Firm. That is Boyette, Cummins, and Nalos. Again, 352-394-2103, 855-LAW-2020. Melissa, you hit it out of the park. You did a great job.
Thank you.
All right, we continue to ask the experts all day long.